I'm reading page 51 of The Name Game, the trick used by the legal system. And this is under Appendix 13. What is Canada? There are several possible interpretations of Canada applicable to common use. The landmass commonly known as Canada. Then there is the nation state, which is the collection of people, commonly called Canada. The property belonging to the name Canada, defined in the British North America Act of 1867. Railways, government buildings, border strip, etc. Schedule 3. Then there is the government and political body, commonly called Canada. Then there's a corporate Canada, used for commerce, home and abroad. Since one cannot conduct commerce with the landmass known as Canada, nor with the property which constitutes Canada, nor with the political body of Canada, it becomes clear that commerce and business can only be conducted with a corporation, such as the Corporation of Canada. Thus, all statutes deal in commerce for Canada, the corporation. The evidence for the corporate Canada is found in Washington, D.C. with the Securities and Exchange Commission's company search for registration number 00002300098. Here we go. Let's see. Here it is. Canada. Business. Canadian Embassy. Business address. Perfect. So, as with any corporation, these are directors, shareholders, employees, officers, etc. Exactly the same structure for corporate Canada. Each year, the budget of Canada, corporate Canada, income and expenses is pledged as the security to back the Corporation of Canada. Let's see here. The United States Securities and Exchange Commission. Okay. Foreign government. Okay, so it looks like this is a structure. And again, if you guys want to read this, you can find the PDF version of this online free. If you want a copy and you can't find it, reach out to me and I can send that to you via email. Let's continue. There are two significant acts in respect of rights and freedoms in Canada. The Canadian Bill of Rights provides rights and freedoms for human beings as natural persons in law. Here's a link. Noteworthy in the Canadian Bill of Rights is the preamble in Section 1 with underlying for emphasis as follows. This is a preamble. The Parliament of Canada affirming that the Canadian nation is founded upon principles that acknowledge the supremacy of God, the dignity and worth of the human person, and the position of the family in a society of free men and free institutions. Affirming also that men and institutions remain free only when freedom is founded upon respect for moral and spiritual values and the rule of law. And being desirous of enshrining these principles and the human rights and fundamental freedoms derived from them in a Bill of Rights which shall reflect the respect of Parliament for its constitutional authority and which shall ensure the protection of these rights and freedom in Canada. Therefore, Her Majesty, by and with the advice and consent of the Senate and the House of Commons of Canada, enacts as follows. 1. It is hereby recognized and declared that in Canada there have existed and shall continue to exist without discrimination by reason of race, national origin, color, religion, or sex the following human rights and fundamental freedoms, namely, A. The right of the individual to life, liberty, and security of person. Listen to this. Security of person. Think about the birth certificate is a person and securitizing that. right? Remember, person could be a company, a corporation, securing, this is the right to securing our person. And enjoyment of property, which is a property, person is property. And the right not to be deprived thereof except by due process of law. B, the right of the individual and equality before the law and the protection of the law. Remember, when you talk about the law right now, we're talking about commercial law right now, because everything is commerce in the public. From the above quoted preamble and the section 1, we see that the Canadian Bill of Rights recognizes the human person, the human being, which we later presume to be the individual so mentioned, as opposed to the security of the person. This word used in section 1a provide evidence that the individual is not the same as the person within the meaning of the Canadian Bill of Rights, to wit, 1a, the right of the individual to life, liberty, security of the person. If individual and person were meant to be the same, section 1a would read the right of the individual to life, liberty, security of the individual, or the right of the person to life, liberty, and security of the person. There is no mistake that the words individual and person were meant to carry different meanings. Such an important statute would have every word correct. If you think otherwise, you are fooling yourself. Now, what about the word security, which is typically used to mean financial backing? Some people mistakenly believe that in this case security means safety, and if that be the case, why would such an important statute not use this phrase safety of the individual? Clearly because that is not the correct interpretation. The use of the words security of the person means the financial security which was hypothecated for the legal person identified by the legal name on the birth certificate. Ha! I knew it. There is no other valid interpretation. Also, from provision 1b, we see that all individuals are equal before the law, meaning that no individual has dominion over another individual, meaning that those who write statutes do not have dominion over other individuals without their consent. The Constitution Act 1867 and 1982, complete with the Charter of Rights and Freedoms as Part 1 and General Provisions as Part 7 of the Constitution Act, provides rights and freedoms for legal persons performing a function of government, and restricts government as to what it can do. Here is the link. Noteworthy section are 32 and 52 as follows. Section 32 states that the Charter of Canada applies to the government and all matters within its authority, viz., those performing a function of government, the actors. This charter, 32.1, this charter applies to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all matters relating to the Yukon Territory and Northwest Territory, and B, to the legislature and government of each province in respect of all matters within the authority of the legislature of each province. This applies to them. This applies to government trustees, all holding office. They can only make rules for themselves and their companies. Section 52 states that the Constitution is the supreme law of Canada. If you read Belize Constitution, it says the same thing. And any law that is inconsistent with the Constitution is of no force and effect. 52.1. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. The Constitution of Canada includes Canada Act 1982, including this Act, the Act and orders referred to in the schedule, and any amendment to any act or order referred to in paragraph A or B. 3. Amendments to the Constitution of Canada shall be made only in accordance with the authority contained in the Constitution of Canada. The combination of provisions 32 and 52 mean that all laws of Canada which purport to apply to individuals who are not performing a function of government and who are going about their own private business are of no force and effect. You understand? So those acts are for actors, not the living men and women. We can act in a commercial capacity and do business as an authorized representative for a commercial entity or a legal entity. That's what we could do. The Constitution Act is part of Canada Act from the UK as follows, and you can click on this. I like how this gives a lot of resources here, so let's click on it. Let's see what happens. All right, let me click on that. It'll take us to the link. Boom, there we go. We can continue reading. Termination of legislation. So let me go back, and here we go. Alright, solution to the name game. The solution to the name game relies upon several well-established maxims of law, together with a process known as conditional acceptance. This solution can only be used after you have received some claim from some government department demanding that you do something you know to be bogus. This solution cannot be used as a preemptive strike because it relies upon their making the first move. The recent court ruling in Meads versus Meads ruled that a foisted claim is of no force and effect, and that is precisely why we let them make the first claim. Then we counter offer asking for proof. With this technique, they cannot use the Meads ruling against us. First, we cover some legal maxims, then discuss the conditional acceptance process. Applicable legal maxims. Firstly, we need to establish some legal maxims. A legal maxim is an established principle or proportion which has been well accepted. Okay guys, so my background noise is getting a little bit too loud, so I'm gonna have to cut it short right now. So this right here, again, if you guys want to read more about it, this is a good read. It's called The Name Game, the trick used by the legal system. I'm currently in Belize, Central America, and I'm working on remedies and working with conditional acceptance as well. So this is good stuff. I've been putting this to practice, and I'm very, very happy to share this type of information because I see a lot of good that can come from it. So if you guys want to read more about it, want to download the PDF, search for it. It's a free download. If you can't find it, reach out to me. Put something in the comments so I can then send this to you via email or some other medium. So you guys be safe, take care, have a blessed day.